Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Good morning. You may be seated. And I see everyone is ready to begin argument in our first case. So, Mr. Suarez.
Thank you, Your Honors, and may it please the Court. Eric Suarez for the petitioner, Mr. Marvin Amaya. Under the precedent established by this Court, a motion to reconsider a decision by the Board of Immigration Appeals can be reversed using the abuse of discretion standard if the agency acted arbitrarily, irrationally, or contrary to law. We ask that the Court vacate and reverse the BIA's denial of Mr. Amaya's motion to reconsider, this as it is in direct tension with this Court's precedent as it relates to persecution, nexus, and relief pursuant to the Convention Against Torture.
Mr. Suarez, can I ask you just about the procedural posture? Do you agree the only thing before us on this petition for review is the denial of the motion to reconsider?
Yes, Your Honor, but in order for us to get to the denial of the motion to reconsider, we must look at why they denied it.
No, I completely understand. And when I read why the BIA denied it, they seem to deny it not on the grounds that it was untimely, not on the ground. They seem to deny it on the grounds that it was wrong, substantively. That's how I read them to deny. But just as a person who used to teach Civ Pro, I think procedurally speaking, do you agree that the only thing that we can actually vacate in this procedural posture is the denial of the motion for reconsideration?
Yes, Your Honor.
So we would send it back to the BIA either to grant the motion to reconsider or I guess at least provide some other explanation for denying the motion to reconsider procedurally?
Yes, Your Honor, or provide a reasonable explanation on the basis of the precedent established by this Court.
Sure, no, of course.
As it relates to those issues. Obviously, we feel that the BIA did not do that. The BIA, as it relates to precedent regarding persecution, did not adhere to it. As it relates to the precedent regarding nexus, did not.
No, absolutely. I agree with all of that. I just think, just make it clear, in this procedural posture, though, we can't actually direct the BIA to grant relief, right? Because all we're actually reviewing is the denial of motion to reconsider.
I agree. I would agree with that, Your Honor.
Okay.
Yes. As to precedent, as we had just mentioned, right, this Court has held that a threat of death alone amounts to persecution. This Court has also held that extortion alone can mount to persecution. As it relates to nexus, the guidance that this Court has given the adjudicators at the agency to consider is whether or not the protected ground is at least one central reason for the reason why this person was targeted. It does not have to be the central reason. It does not even have to be the dominant central reason.
And now the IJ and the BIA considered it merely an incidental nexus to the MS-13 targeting your client. What's your best argument that it's more than just incidental?
Yes, Your Honor, I believe the facts lead that on all by themselves, right? The facts in this case indicate that the respondent from 2001 to 2005 was targeted by the MS-13 gang for recruitment. This is at page 109 of the record. He indicates that he was targeted about 5 times and threatened with death. He says, quote, "They told me that they're going to cut my tongue out and they'd kill me." Page 110 and 111, he indicates that the gang knew.
Didn't they say they would decapitate him?
That they would
next
cut
time
his
or
tongue out
something?
and kill him.
Yeah, okay.
They also said, Your Honor, page 110 and 111, that they knew that his family was here in the United States. He says, they wanted my brothers, the brothers of mine, they wanted them to finance their crimes. On page 120, he says, quote, "They said I had siblings in the U.S., and if I joined them, the gang, they would finance their activities, the siblings." This is time and time again pointed to by evidence in the record, substantial evidence in the record, that demonstrates that this is the reason why he was initially targeted. But it doesn't stop there. His brother, Victor, was murdered by the gangs because he also refused to join, because he also refused to have an avenue in which the family that was here in the United States could continue to provide for the gangs. Victor moved to a different place in the country. Victor was still found by the gangs, and the gangs still murdered him. And not only that, Your Honor, when the gang in January of 2005, they stopped him, they beat him, they told him again that he had to join, they cut him with a knife, he refused. His sibling subsequently fled to the United States, and his other brother, Moises, who remained in El Salvador, was also targeted by the gang for the same reason. He was targeted for recruitment. He was targeted, refused to join. They wanted him to be a sort of mule to carry drugs for them and transport drugs for them, and he also refused, and he was also targeted by the gangs. So we believe that the facts themselves bear out.
Can I ask you to talk about the theory that it's the thing that I think, in my sense, the BIA didn't really address at all, is the theory that he would be killed as a stand-in for his brother, so that one of the arguments I understand him to have made is the gang would like to get at his brother's in the United States, the gang can't get at his brother, and so if he is back in El Salvador, the gang will target him as a stand-in for his brother. Could you talk about that for a moment?
Yes, Your Honor. This is as it relates to specifically the 2014 threats that his brother Moises referred to. Now, we feel that the BIA nor the IJ considered any of this evidence when they made their determination. But
and the theory there, the reason for the nexus there is the reason, if you go to that hypothetical that says the gang would really like his brother, they can't get his brother, so they would kill him instead, that is on the grounds of his family status, because the reason he would be targeted is because of who his brother is. If his brother was somebody else, he would not be targeted? Is that
That is correct, Your Honor, and we believe also that the evidence bears that out as well. On page 104, he testifies to the fact that he is completely certain, Mr. Amaya, and I quote here, "I am completely sure, because I am his brother, and if they don't find him, they will take action. They will act." He says on page 107, quote, "They know that I am his brother, and if I were to go back, they would act because they want people to respect the laws of the gang," implying that because his brother fled, his brother refused, they would target him and his family. Not only that, on page 124, he says, quote, "If they don't find the person that they're looking for, my brother, they will find me instead. They would kill me." And he says as well on page 106 that his home, the family home where he would have to go back to, has now been a target of the gang. It's been, quote, "marked by the gang," which means that they're not only looking for his brother, but they're looking for anybody who could go back to this home. Anybody who's a member of this family who goes back will be targeted and threatened and persecuted. So we believe, Your Honor, that the facts bear this out, that this is something that the board failed to consider, that the IJ failed to consider as it relates to both persecution and as it relates to nexus. The president of this court is clear, and the board failed to consider that. We brought that up to the board in the motion to reconsider, and the motion to reconsider in this case articulated the reasons why the board should have made the determination that it did, and it refused to consider them again when it came to its decision denying the motion to reconsider, which is why we are before this court today. This court, in many occasions, has said that time and time again they have rejected arguments where the board has excessively narrowed the determination as it relates to nexus. And we asked this morning for the court to do so again, because the board here has failed to meet its standard, has failed to meet the determinations that...
Do you want to make any argument about the country conditions in your Convention Against Torture
Yes, Your Honor.
piece of this?
Yes, as it relates to the Convention Against Torture, Your Honor, the board and the IJ failed to conduct the proper analysis here that this court has indicated for them to do. In the Rodriguez-Arias analysis, the board and the IJ should have weighted the evidence and considered all aspects of persecution in this case. It did not do that. The IJ focused instead on the fact that he was, I believe the IJ used, it's brief indulgence. The word that the IJ used was nagged by the gang for a couple of years. The IJ...
I guess my question was going to the country conditions argument. In your brief, you said that they below they failed to address all of the country conditions. What's an example in the record of country conditions evidence that the lower courts failed to consider?
Yes, Your Honor. The court basically, the only thing that the lower court considered in this particular case was a citation to the fact that the record demonstrated that there were some instances relating to actions by the police of some activity to address the gang. That's not what the record bears. We submitted, initially, we did not do this case, but the attorney that submitted this case initially submitted country condition evidence indicating that the gangs were countrywide, that the gangs in this particular case would target Mr. Amaya anywhere because of their reach, that the police in this case would be unable to act. And that's not only bared out by the country conditions, Your Honor, by his own statements in testimony. He indicated that the police are corrupt, that the
Did he
police-
report it to the police?
He did not report it to the police, Your Honor, because in this case, the police who picked up the body of his dead brother did not investigate the death of his dead brother. And so he felt like, and he articulated in testimony, that it would be futile, essentially, for him to report this issue to the police because the police did not act in his brother's case, did not act in other cases in the country. And for that reason, he did not report it to the police. But as Your Honors know, and it's not required that he report this issue to the police if doing so would not cause a result, would not cause action, would cause him more harm. And that's exactly what would have happened in this particular case. And as it relates to the consideration of the evidence in this case, the IJ, it will note from the record, the IJ did not receive the actual evidence in this case until the hearing had already begun. How could the IJ have considered properly the evidence that was submitted, the articles that were prepared, the affidavit that was submitted in this case, if he received the evidence mid-trial? That would not fly in this courtroom. That would not fly between counsel and I. A law student would not do that if they were preparing for an exam. Why would we allow an immigration judge to do this and to conduct an analysis this way in a hearing that is so meaningful, where he is holding the respondent's life in his or her hands? We should expect more from them at this point. Your Honor, I'll close on with this court's own words relating to what we expect or should expect from the adjudicators in this particular case, or in cases of this nature. In the Rodriguez-Arias decision, this court indicated that when a man's life is on the line, they should know that the arbiters in their case reviewed the record thoroughly, reviewed the record fully, and made the best decision that they could based on the law. That did not happen in this case. And for those reasons, we request that this be vacated and remanded for the board for consideration under this court's precedent.
All right, thank you. You have some time in rebuttal. Mr. Coleman?
Thank you, Your Honors. May it please the Court. My name is Robert Coleman, and I represent the Attorney General. Turning first to the CAT claim that was addressed most recently on the opening argument, there was no claim made below that there was insufficient time for the immigration judge to review the evidence, and no ineffective assistance of counsel type argument that was made below. So that type of argument would be unexhausted. But nevertheless, the immigration judge and the agency demonstrated that they reviewed and considered the country conditions evidence by acknowledging that there are extreme difficulties in El Salvador regarding crime and organized crime and corruption, but that there is evidence in the country conditions reports that indicates that the authorities are making some efforts and some inroads to remedy that situation. And that is all that petitioner is entitled to, despite the pure fact that the petitioner sees the evidence differently is not enough to disturb the decision below. And again, as was addressed during opening argument, the only decision on review for this court is the motion to reconsider. So that is evaluated purely on the abuse of discretion standard. And so the question is not whether the board adequately affirmed in the first instance that decision was not appealed to this court.
Right, but abuse of discretion includes an erroneous application of the law, does it not?
That is correct, Your Honor.
And we've been pretty clear in our cases that in order to establish the connection here, the nexus, that the particular social group only has to be one central reason. It doesn't have to be the sole reason, and I'm sure you're very familiar with that line of case law. And how could the family relationship not be one central reason under the facts of this case? This appears to me to be one of the stronger cases that I've seen recently in terms of family relationship as a particular social group.
Well, it isn't, the evidence is not indicative that this was actually one central reason, the family relationship, because we have, if you turn it to page 120, where the petitioner gave the notification or notified the court that the gang at one point mentioned his family, he said that if I were to join the gang, then they would expect my family to finance their activity.
Right, but he also said they personally threatened him.
But not
Isn't
for
that-
that reason.
Excuse me?
Pardon me, Your Honor.
Yeah.
Not for that reason.
Right, but that was the beginning. That was the beginning of his relationship with trying to repel the gang. And then they murdered his brother, and then his other brother fled, and then he said, and the IJ did not make a credibility determination, so there's a rebuttable presumption of credibility. And then the petitioner said, well, if I'm sent back, they're going to get me because they couldn't get Moses. Well, with a presumption of credibility, why doesn't that carry the day for him that there was an erroneous application of law in this case?
And I would
Because-
add to that line of facts that they also marked the gang also marked the family home.
Yes, and to deal with that issue first, on
Well,
page 20
I would deal with Judge Keenan's issue first.
I understand. Will do. Thank you. The testimony indicates that although Amaya was targeted, threatened, and harmed, it was because of his resistance to gang membership. And that is not a nexus. That
But
is
it
not
seems to me that what you're trying to do is isolate each piece of evidence rather than consider the whole factual context of what we have here. Sure, if you just take one thread of what happened, you can say no, there might not have been a tie. And then you take another and you can isolate individual facts and say standing alone, they wouldn't create an aggregate situation. But if you look at the entire factual context, how can you say that he didn't fear future persecution based on his family relationship?
Because the mere mention of a family relationship is not enough to demonstrate that the family relationship is one central reason. And this court has case law.
But he's got the presumption of credibility here, does he not? Under the case law?
Assuming that he is credible, yes. Assuming that he is credible.
Well, he is credible for our purposes of review. He is credible.
Yes, but he didn't say he was threatened. He doesn't even claim that he was threatened because of his family relationship. He says that he was targeted, threatened, and harmed because he resisted gang recruitment. He now mentions that the gang did mention his family relationship, but just that mention is not enough. Under Cortez Mendez, this court affirmed a similar circumstance. There, the facts were even stronger, actually, where a family membership was mentioned in the context of a threat issued to the petitioner. But the court found that was not one central reason because as here, there was testimony from the petitioner himself saying, the reason why I was targeted and threatened was because of gang recruitment efforts. And that goes along with the finding that the agency made here that this was merely an incidental or tangential relationship to the actual central reason, which was because of the gang recruitment.
Can I give you a hypo? And I want to be clear, I recognize the obvious similarity of the facts of this case, but I want to be clear this is a hypo, so please don't fight the hypo and the truthfulness of the hypo.
Understood.
So what if a criminal group, targets my mother for something? And let's posit that they are not targeting her on a particular social group. They're targeting her for reasons completely unique to her, right? But for whatever reason, my mother is very good at evading them, and so she is not someone they can get at. And so we know, and again, that we know for certain that the gang their inability to get at my mother, they're going to kill me as a proxy for my mother, right? They're going to do that if they're not able to get at my mother. In fact, maybe they call my mother from her safe space somewhere far away and say, if you don't come back and surrender yourself to us, we are going to kill your son. Is there any question that in that situation, the threat against the son is based on an identifiable social group?
There is a question because we would need to know what the social group is.
The family. I'm going to kill you because let's posit further that we know for sure that if this person was not her son, they would not be targeting them. They're going to kill him as a proxy for her because he is her son. If that's true, is there any question that that's based on an identifiable social group?
I don't believe there is any question in that case.
And then why doesn't that just resolve this here? Because here this gentleman testifies, if he testifies and there's no finding of lack of credibility, he testifies they want to get my brother. If they can't get my brother, they will kill me because I'm his brother. How is that any different than my house? Now, again, maybe he's not credible, maybe he's not believable, maybe that's not true, maybe an IJ could, but here we don't have an adverse credibility finding. So why isn't that just this case?
We don't have an adverse credibility finding here, but we do, what we're limited to is his unsupported assertion in his testimony. And as this court indicated in Cortez Mendez, just an unsupported assertion that the family relationship will be the reason why he'll be persecuted isn't enough, particularly in the context of, as we have here, testimony coming from the petitioner himself saying the reason why I was targeted, threatened, and harmed was because I resisted gang.
But that strikes me as the fundamental mistake the BIA made, which is that they didn't differentiate past persecution from a risk of future persecution. I agree that a lot of the evidence in this record is consistent with the notion that to the extent this individual suffered past persecution, it wasn't based on an identifiable social group. But under asylum and withholding, past persecution is just evidence of the thing we actually care about, which is future persecution. And I don't see the BIA grappling at all with his testimony that says, I fear something bad will happen to me in the future because of my relationship with my brother.
And I believe that's because it's just unsubstantiated.
But they don't even say that. They literally don't even mention this possibility.
And the statute addresses well-founded fear of persecution. The statute doesn't have to say evidence of persecution or evidence that I will be persecuted. It's a well-founded fear.
Correct, but the issue is then, is it well-founded when you have no evidence and you're left merely with supposition?
Right, but the government didn't target his credibility. There's a rebuttable presumption under our case law. I mean, you could have gone after his credibility at the hearing.
Yes, but there's still a question as to whether the evidence is sufficient, regardless of credibility. Just because the individual is found credible doesn't mean that they automatically have met their burden of proof.
Well, what would the evidence be? What else is it you would want him to do other than say, this has happened several times, this is why I'm afraid?
He could have provided his brother as a witness, which
well, one's dead and the other is, fled El Salvador.
Right, he's now in the United States, and he was listed as a witness who was supposed to attend the hearing, but then he didn't attend, and he didn't provide a declaration either in support of his brother's petition. Furthermore, the evidence regarding the brothers is cloudy at best here.
Which brother are we talking about here now? The dead one or the one that had to flee?
Both.
Okay.
As far as Victor is concerned, that's the older brother who was killed in El Salvador. The evidence is unclear whether it's even his brother or not. On page 153, there's a birth certificate for Victor, lists different parents than the parents listed in the 589 for Amaya himself. So to the extent there was any family relationship as far as why Victor was killed, we don't know what the relevance of that is in particular. And further, that was before Amaya here had his interaction with the gang. So if Victor's interaction with the gang was going to influence how Amaya was treated, that would have already happened. Moreover, as far as Moises is concerned, and I should state too, we don't have any evidence in the record that any gang members know that these three individuals are related. There's no evidence of that whatsoever. Further, as far as Moises is concerned, Amaya testified directly about his understanding of what happened to Moises. He was asked about his relationship to Moises. He said, I was very close to my younger brother, Moises. He told me what happened to him. And during his testimony, he says the reason why he was targeted was because he failed to comply with the request of the gang to serve as a drug mule. He was then asked, was there any other reason? And he said, no, that's the reason. It was because he failed to comply with the gang's request, which is completely in keeping with why Amaya was harmed, threatened, and targeted originally. It's because he was originally of gang recruitment age, which he no longer is presumably, but even putting that to the side.
And it was also because of his family membership, because you pointed to JA 120, and there he said that the gang told him they knew I had siblings in the United States, and that if I joined them, they would have to finance their activities. So he was targeted initially because of his family relationship.
That's not what he said. He said, if I join, he doesn't say I was targeted because of my relationship, whereas he does say I was targeted.
I don't know what that sentence would say other than that was their intent.
Well, he just doesn't.
So He has to say the magic words, "I was targeted because of my family relationship," because the question he was asked is, did they ask you for anything other than joining them? And he says, they said they knew I had siblings in the United States, and if I joined them, they would have to finance their activities. So the gang is connecting the gang recruiting him to his family in the United States.
But that puts this case very close with Cortez Mendez, where there was also a similar mention of the family relationship, but there is no claim that the threat was contingent on the family relationship. So just that mere mention of the family relationship, I agree. It's a little strange that that's just in there, that they would mention that, but that's the evidence that we have here. And so the evidence is, it's contingent in that it says if I joined, then they would support the gang financially. But more than that, just the mere mention isn't enough. And here the agency acknowledged that this happened. It just found that this was purely incidental or tangential to the real reason why he was targeted. It was because of originally because of his gang recruitment age. He was roughly 16 at the time when he was originally approached. That's 97 and 98 of the record. And then as he testified, he was threatened, particularly when he was beat up on the one occasion that he was physically harmed in 2005. He testifies that that's because two individual gang members approached him, said, "You need to join." He said, "No," they beat him up. There was no mention at all of the family relationship there. There's no evidence that those individuals even knew of the family relationship, him having family in the U.S. And again, there's no evidence at all that any of the gang members knew that these three individuals were related, much less that they would still know that all of these years later. As we're talking about, Moises's interaction with the gang was almost 10 years ago now, and Amaya and Victor's interactions around 20 years ago. If the court has any further questions, I'd be happy to answer those.
All right, thank you.
Thank you very much.
Go ahead.
Your Honor. Your Honor, I'll make two brief points. First, as it relates to the opposing counsel's claims that the record is unsubstantiated, the regulations tell us clearly that evidence of testimony that is found to be credible is enough to establish that the facts of the case bear out that the incidents actually happened. They don't have to have a document that demonstrates that the applicant's own testimony alone is enough to establish that. As it relates to Cortez Mendez, Your Honor, this case could not be more far apart from Cortez Mendez. In Cortez Mendez, there were other family members that were unharmed in this particular case. And Cortez Mendez, the applicant in that case, specifically testified that his rejection of gang membership was the impetus for his harassment. That did not happen here. The record here clearly bears out that he testified from the get-go that the reason why he was targeted is because he had siblings in the United States as it relates to the initial threat, and that and the reason why he will be targeted if he returns as it relates to future persecution is because of his brother Moises, who was targeted by the gangs. That is the basis for this claim. Could not be farther apart from the Cortez Mendez case that the department cites. Cortez Mendez, as I mentioned, did not have any of these specific incidents, and he himself testified to the fact that he was targeted for another reason. But here we have met the standard that this court has laid out time and time and time again. The basis for why Mr. Amaya was targeted and why he will be targeted in the future is because of his relationship to his family, and that is at least one central reason why. Thank you so much.
Now, Mr. Coleman argued that there's no evidence that the gang knew that he was related to, I guess, Victor. What's your response to that?
He bears that out in the record, right? He says in the record why Victor was targeted too. He was related to Victor by claiming that he was his brother. That is admitted part of the undisputed facts of the case. The department may bring out the fact that there were different parents listed on test. This was not an issue on the record. We don't have an issue of disputing his relationship to Victor. The gangs targeted Victor for the exact same reason why they targeted him, because both of them had siblings in the United States who could finance the gang's activity. That is the reason why they were targeted and not somebody else. That is the reason why Mr. Amaya was targeted and not somebody else, his relationship to his siblings who were in the United States. Thank you.
Thank you. All right, we'll come down and greet counsel and go to our next case. All right, we're ready to hear argument in our next case, Bledsoe versus Cook. I'm sorry, not Bledsoe versus, yeah, it is. All right, Mr. Bledsoe, go ahead.
Morning, Your Honor. May it please the court, my name is Joseph Bledsoe, and I am the Chapter 13 trustee in the bankruptcy case of Robert and Cheryl Cook, no relation to opposing counsel. The issue in this case is whether or not the bankruptcy court erred when it determined that it had no discretion to consider the reasonableness of the debtor's average contractual monthly mortgage payments. In this case, the debtors filed a Chapter 13. They completed the means test because they are above median income debtors. The means test would have given them a mortgage deduction of about $1,100, give or take. I think a few dollars short of that. They took a deduction on the means test for about $2,200, 22 plus some change, which was more than twice the amount. The trustee objected. My argument was not that the debtors are not allowed that deduction, but that to the extent the debtors want to take a deduction that is over and above what the means test allowed, they have to show reasonableness. And I think that's fairly clear from at least my interpretation of the statute.
Can I just ask you, I mean, this seems like a totally reasonable argument, and I think on balance, I can understand why you'd want to give bankruptcy courts more discretion rather than less. But why isn't that just antithetical to the Bankruptcy Abuse Protection and Consumer Act? I understand why bankruptcy courts might not like having less discretion. I understand why trustees might not like bankruptcy courts having less discretion. But isn't this a statute that by its very nature takes discretion away from bankruptcy court judges?
Well, I think it does take some discretion away, but not totally. And in terms of that specific deduction, if you read 707B2A2, and it talks about the debtors, what they're allowed in terms of their deductions. When it comes to the mortgage deduction, it says the debtor shall be allowed a monthly expense in the amount specified. So the way that the bankruptcy code breaks it down, you have the first, and I'm going to adopt Mr. Cook's terminology here. You have the first clause, clause 2. And that deals with the national standards, the local standards, and the other necessary expenses. And then clause 2 has several different subclauses. Then you have clause 3 and you have clause 4. Clause 2 specifically deals with the mortgage deduction, and it says the debtor shall be allowed a mortgage deduction in the amount specified. It doesn't say in the amount specified unless the debtor wants to claim something else. And if you look at the structure of it, the way you have the national standards, which is the mortgage expenses and the utilities expenses. You have the local standards, which is the vehicle operation and ownership expenses. The other necessary expenses, the IRS kind of divides those expenses into two categories. You have other necessary expenses and you have other conditional expenses. Now the rest of, most of the rest of Clause 2 and Clause 3 and Clause 4, they kind of incorporate what the IRS would consider under those other expenses, whether they're necessary or conditional. So for example, if you've got Clause 3 that talks about...
Can I ask you, under your reading, what is the point of Clause 3 in this situation? What work does Clause 3 do?
I think Clause 3 is a formula. I don't think that the debtor is not going to be entitled to any secured debt deductions. I think that there are times when a debtor could be allowed a secured debt deduction.
But not the full amount of the secured debt?
It depends on what the debt is.
I guess another way to think about this, it seems strange to me, admittedly, it's been a while since I took secured transactions or bankruptcy, but I mean, the fundamental principle is that secured creditors get paid in full. I mean, like, telling me that I can take a mortgage interest deduction for half of the amount of my mortgage is just another way of saying I can't pay my mortgage, is just another way of saying I can't stay in my house, because my secured mortgage company is not going to accept 50% of my mortgage payment as full payment, and what they're going to do is they're going to exercise their security interest, right?
That's right.
So that's telling me that I can't actually stay in my house.
Well, not necessarily. I would say, first of all, I would say if Clause 3 is a standalone provision which allows the debtor to deduct secured debts, regardless of what kind they are, then you have a stronger argument, except that this particular secured debt is already addressed in Clause 2. It's already addressed under the local standards. And it says that.
But I don't see how that's responding to my view that in this view, you're actually telling debtors they can't stay in their house because, let's just take these debtors. Your position is these debtors can deduct half of their monthly mortgage payment, which means the bank is going to foreclose, which means they can't stay in their house, right?
No, my position would be, I think, better stated that the debtors can stay in the house and they can maintain that mortgage payment. But
How?
The bankruptcy court can make a finding that to the extent the mortgage payments exceed the amount of the IRS allowance, that's nevertheless reasonable. And in a lot of cases, that's going to be the case. I think, it's a matter of degree. If you have debtors that come in and let's say 20 years ago, they bought a house and they raised their family in that house, and then they got some repairs done on that house. They put a new roof on it. They put a new floor on it. Now they have mortgage payments that exceed the IRS allowance. The bankruptcy judge could well find that that's reasonable under those circumstances and allow them to stay in the house.
Can I ask you, has any other court of appeals agreed with this interpretation of the statute?
Your Honor,
I believe the answer is no.
Well, I think that the more accurate answer is none of the other courts of appeals have addressed this specific issue.
Well, what about the Sixth Circuit and the Ninth Circuit in Bald and Drummond?
Thank you, Your Honor. In the Sixth Circuit, the issue was a little bit different. In both of those cases, the trustee basically conceded that the means test, as constructed, would allow this kind of deduction. They didn't challenge whether the means test actually says that. In Sixth Circuit, what the trustee said was, well, yeah, I know that the means test allows this mortgage debt deduction, but the means test should really only be a starting point for the consideration of disposable income. What we should really look at is Schedule I. In other words, that trustee, and I don't agree with that trustee at all, said we don't care about the changes to the law. We don't care about the means test. We want to go back to the way it was.
But didn't the Ninth Circuit and Welch pretty much nail down the argument against your position when they said that disposable income, the calculation requires debtors to subtract their payments to secured creditors from their current monthly income. Congress did not see fit to limit or qualify the kinds of secured payments that are subtracted to reach a disposable income figure. Why would we then read into the statute, that little subsection 3, any limitation on secured debt when the statute itself, in that subsection, talking about secured debt, makes no limitation?
Well, Your Honor, first of all, I would say that in the Welsh case, again, the issue wasn't in front of the court specifically in that way. In the Welsh case, the trustee again said the means test allows this deduction, but to allow the debtor to take this deduction while paying this minuscule amount to his unsecured creditors, that's just not good faith. Well, that's not a good argument. I mean, I was a debtor's attorney for 20 years before I became a trustee, and that's an easy one to knock out of the park. If the code does actually allow for this deduction, how can it be bad faith to ding the debt? I mean, how can it be bad faith for the debtor to actually step up and take the deduction to which he's allowed? So the trustee in that case argued the wrong thing. And I think in answer to your question, if you read all of the different clauses and subclauses around Clause 3, the wording is different, and it should mean something. In every single one of the other clauses, it talks about the debtor's allowable expenses. It doesn't talk about that in Clause 3. It basically just sets forth a formula for calculating the amount of a secured debt. Whether or not that secured debt should be allowed should be considered in the totality of 707B. It should be considered as whether or not it would be an other necessary expense under the IRS's definitions. Because in the IRS manual, again, you've got other necessary expenses and other conditional expenses. For an expense to be necessary, It has to be an expense that's reasonably necessary for the health and welfare of the debtor, or it has to be an expense that the debtor incurs in generating income. If it's not a necessary expense, it's a conditional expense, and there are a number of different examples. Congress, in its wisdom, decided that it was only going to allow deductions for other necessary expenses. Now, I think the question is, does each one of these separate little clauses and subclauses, are they standalone provisions that say you get this deduction in this amount? If it is, if each one of them stand alone, then I have to concede. Mr. Cook and the debtors win in this particular case. But I don't think that's a proper reading of it. I don't think that's consistent with the purpose of the means test, as explained in Ransom, where the court said the purpose of the means test is to make sure that debtors who can pay their creditors do pay their creditors. There's also dicta in Ransom that specifically talks about, now, Ransom was about a case where the debtor had no car payment, but there's dicta in that case where the Supreme Court says if the car payment had been higher than the IRS allowance, the debtor would be limited not to the actual amount of the payment, the debtor would be limited to the IRS allowance. Now, it's dicta, but it's important dicta, and it's directly bearing on this. So I think what you have here is Clause 2, that deals with mortgage debts, at least debts that are secured by the debtor's primary mortgage, primary residence. Then you have, in that same section, debts that are dealing with the debtor's primary vehicle. If it's not one of those types of secured debts, then it's not dealt with under a national or local standard. It's only dealt with as an other necessary expense. And if you read all of the 707B2 together and you say these kind of work together in concert with each other, then you have this way to calculate a secured debt, but it still has to meet the necessary expense category before the debtor is going to be allowed that. But even beyond that, you still have the problem. That's really more with respect to other debts, like the debtor buys an air conditioner right before he files bankruptcy. Is that going to be reasonable? Probably so, especially the deeper south you go, you're going to need some air conditioning. So that's going to be a reasonable debt, and that's going to be an easier one to do. But since 707B already specifically addresses the mortgage debt, and it says you will get this specific amount, the only way you can get more than that, it seems to me, is if you go to special circumstances, and that's provided for. You can go to court.
When you say it specifically addresses the mortgage debt, what do you mean by that?
Well, the 707 B2A21, the debtor's monthly expenses shall be the debtor's applicable monthly expense amounts specified under the national standards and the local standards.
So the national, okay, so that I thought so. That statute doesn't say your mortgage. It doesn't say on your primary residence. It refers you to these IRS forms, right?
But the local standards include, local standards are comprised of the residence mortgage expense.
Well, it has all kinds of things. So am I correct that the principal purpose or the pre-existing purpose of those standards is for IRS purposes, it's for tax purposes, and that what the bankruptcy code is just doing is saying, rather than so it turns out when people owe the government taxes, you have to figure out how much money they have to devote to taxes to other things. And not surprisingly, the IRS has a big interest in that. So they promulgate all these forms to figure out how much you owe the IRS in taxes. And then the bankruptcy code comes along and says, we could create new standards, but it turns out the Treasury has already done these for tax purposes. So rather than reinvent the wheel, we'll just reference those. Right. That's what the bankruptcy code basically does?
That's basically what I think it does.
Okay. Well, so then it doesn't mean that every single thing that's in one of those IRS standards has to necessarily apply in bankruptcy. That's the link I'm not sure that I understand.
Well, I think if you read all of 707B2 again, all of the different subclauses of Clause 2 deal with expenses that are covered in the IRS's other expense category. So basically what Congress did, they said for each of these type of expenses, we don't need the bankruptcy court to judge those. Those are going to be reasonable expenses. But it deals with, if you go down that list, nowhere on that list does it address a debt for the debtor's mortgage for the primary residence or for the primary vehicle. It doesn't have to because those are already specifically addressed in the national standard. And this court kind of came at it the other way in the Jackson v. Lynch case where the bankruptcy administrator for the Eastern District was arguing if the average mortgage payments are lower than the IRS standards, well, that's what the debtor should be able to deduct on the means test. And the court said, no, the statute doesn't say that. The statute says you get the amount specified. Why do you get the amount specified? But if the debtor doesn't like that amount, they can go over to the secured debt deduction, which under the IRS, and the Supreme Court has said, you can consult the IRS manual for interpretation of how these things should be applied in bankruptcy.
Do you agree with me that the Lynch decision never expressly addresses whether or not mortgages are properly dealt with under Clause 2 or Clause 3? I mean, I agree that Lynch talks about Clause 2, but I don't see anything in Lynch where the court is actually dealing with an argument. And I think I went back and looked at the briefs, and I don't think anyone in Lynch in the briefs was arguing about whether it was Clause 2 versus Clause 3.
I think that's correct, Your Honor. I think that there was no reason to get to the Clause 3 argument in that case because Clause 3, the average contractual payments would have gotten you to the same place as Clause 2, and that's not what the debtor wanted in that case. So I would absolutely agree with that. But I think if Congress takes the time and sets up and says, we're going to address the mortgage and the primary vehicle under this section, then there has to be some indication that Congress also meant to allow a spillover if the debtor didn't like that result. And again, I'm not saying that the debtor's going to lose their house. If the court were to vacate and remand back to the bankruptcy court would have the opportunity to review this and say, well, under these circumstances, this is a reasonable expense or this is not a reasonable expense. And I think all of the kind of good faith arguments that this court has considered before would go into that. If the debtor's been in the house a long time, they raised their family there. I mean, frankly, I'm not even going to raise an objection in that case because just common sense says there's nothing wrong here. But the debtor who buys the house 6 months before and it's 4 times the IRS allowance, there should be some mechanism, and I think the code provides that mechanism for the bankruptcy judge to review that and see, is that reasonable under these circumstances?
All right, thank you. You have some time in rebuttal. Mr. Cook?
Judges, and may it please the court. My name is Richard Cook, and I represent the appellees, Robert and Cheryl Cook. As the trustee pointed out, there is no relation.
I think that's what confused me in the beginning. The names are the same.
It's quite the coincidence. In 2005, Congress made very clear with passage of what I will refer to as BAP-CIPA, the Bankruptcy Abuse Prevention and Consumer Protection Act. Under BAP-CIPA, Congress intentionally removed judicial discretion when determining whether or not a consumer debtor has the ability to repay their debts. In a Chapter 13 context, a means test was created. The means test mirrors a lot of Chapter 7, but looking to the Chapter 13 means test itself, you take the debtor's current monthly income and you subtract amounts reasonably necessary to be expended. And I'm putting those in quotes because it reads from the statute. I'm going to read verbatim here if you indulge me. When you're deducting expenses on the Chapter 13 means test, amounts reasonably necessary to be expended shall be determined. Use of that word shall is very important. Shall be determined in accordance with subparagraphs A and B of Section 707B2. So this is where the Chapter 7 means test is incorporated into the Chapter 13 means test. But Congress was very explicit with the Chapter 13 means test that the amounts reasonably necessary to be expended, if that amount shows up in the Chapter 7 means test, Congress has already said it's reasonable. There doesn't need to be a separate reasonableness determination. Use of the word shall, as we know, mandates the statute must be followed. The courts lose discretion with use of the word shall. Turning to the Chapter 7 means test incorporated in Chapter 13, if you look at 707B2, we'll call it Clause 1. Under Clause 1, it says you can the current month that you deduct expenses that appear in Clauses 2, 3, and 4. It doesn't say just Clause 2 or just 3 or just 4. If it appears in any of those 3 buckets, you get to claim it. If you look at Clause 2, which is what the trustee is focused on with the IRS standards, halfway through that particular clause, it is crystal clear. It says, notwithstanding any other language in this section, this does not include debt payments. We don't. So we know Clause 2 has zero application when we're discussing mortgage payments, because Congress has told us that. Again, it uses the word shall. If you look at the forms, if you turn to the joint appendix, you can see the official forms which debtors are required to use. There is no choice here. You don't have, in some districts you can use a different means test. No. The whole country uses these official forms and they're required to by Rule 9009A of the bankruptcy rules. These official forms, you can see it in the joint appendix.
What level of deference do we owe to those forms? I mean, the forms don't have the status of positive law, so I guess in principle, one of the forms could be inconsistent with the statute, right?
Hypothetically, yes. What I can say, though, is Rule 9009C tells us we actually give the forms deference. We are to interpret the forms to be consistent with the relevant bankruptcy law.
Well, that's not what you're doing here. You're asking us to conclude that the code means what the forms say, not that the forms mean what the code says.
Well, I think they kind of tie into each other, because I think they're one and the same. Because if you look at the specific example, if you look at joint appendix on page 68, so it's paragraph 9 of the means test, where it discusses the IRS standard for a housing expense. What it does is you list the IRS standard for your household size for a housing expense, but then you simultaneously deduct from that your actual mortgage expense. And so in a situation like here, we have 0. And so like it follows, the official form follows clause 2 in that clause 2 does not include debt payments. And so because this debt payment is larger than the IRS standard, we actually don't have a deduction under clause 2 here for the mortgage payment. And so I think that is a scenario where you see the forms mirror the statute. So where clause 3 comes into play on the actual means test, and you see it in this case, page 71 of the joint appendix, it's paragraph 33 of the means test that says, list your secured debt payments, secured by a mortgage, your house debt, car debt, you list all of them, and there are no qualifiers. It doesn't say only the reasonable ones, only this, because we know, because you look at clause 3 itself, clause 3 doesn't have any qualifiers. It says you shall calculate secure debt payments as the total of all contractual payments that come in the next 60 months, you divide it by 60. And that's exactly what was done here. So
Can I just make sure that, so in the real world, the upshot of your position is that a debtor who actually has a mortgage, you have to have a mortgage, right? That's the case about you, in order to deduct your car payment, you actually have to have a car payment. So a debtor who actually has a mortgage, am I right that the practical upshot of your position gets the higher of their actual mortgage payment or the IRS guideline?
correct. In the easy, it's doing the math calculations going back to paragraph.
Right, but at the end of the day, they're going to get to deduct the higher of those two numbers? Is that the
Correct, and
option?
that's exactly what Judge Thacker wrote in Lynch versus Jackson, is you get the higher of the two. That's just how the statutes are written. Is you don't punish frugal debtors. This is exactly what you said, Judge Thacker in Lynch versus Jackson. You don't punish somebody who's saving and frugal. But here you're going to punish these debtors because, the whole point of BAP-CEPA was those who can pay must pay.
But wait, so that was true in Lynch. In Lynch, we weren't going to punish debtors who are frugal. We don't punish debtors who have a mortgage that's cheaper than the local average. But your friend on the other, the best practical argument I think they have is you're rewarding debtors who are profligate, right? So by definition, if you're in bankruptcy, you are someone who has more bills than income. That's what it sort of means to be bankrupt, right? And so under your rule, someone who took out a mortgage on a house that they absolutely positively could not afford, the opposite of a frugal debtor, a profligate debtor, a house poor debtor, gets to keep from their unsecured creditors the entire amount of their massive mortgage payment. I don't see how that's protecting frugal debtors. That seems like it's rewarding profligate debtors.
Well, what I can say, and this was touched on in the Ninth Circuit case in Welch, is that there'd be an argument in that scenario of bad faith. I think one of the cases they were referencing in the Ninth Circuit case was the debtors had a $5,000 mortgage payment, $5,000 a month mortgage payment. I think then we drift into bad faith. But, I don't mean to sound callous like this, but Congress makes these policy calls.
Sure.
Like that's, you say judges are here to call balls and strikes. What did Congress write? Well, Congress wrote that judges can't make these decisions. They've tied these judges' hands. And part of that is stability in the mortgage market. Like you were pointing out during opening argument, is what's the recourse here? Like, what do we do then if these clients here, the Cooks, if they had to dedicate an extra $1,100 a month into a bankruptcy plan that they don't have, that's over and above their actual mortgage payment. So then are they going to have to triage then, okay, what are we letting go now? Do we have to let go, the car we had to have, we're going to have to let that go, or we're going to have to let go of the house. So how do you promote stability in the mortgage market? By requiring people to surrender their homes just to afford their bankruptcy repayment plans, even if they were current in the mortgage when they filed, which is what we have here, even if there's no equity above exemption, which creditors can't touch, again, we have here, you're going to force people out of their houses to comply with a made-up test that Congress says you don't have to. Because going back to, BAPSIPA was, if you have the ability to pay, you pay. But here, this isn't that case. Like, they're paying over and above the mortgage. Like, you're asking them to pay over. It's not like there's some savings sitting around here and we're gaming the means test.
Could you just walk me through the code how that example you gave of the debtor with the $5,000 mortgage, that would be bad faith. So how could a bankruptcy court, notwithstanding your view of BAPSIPA, get to the point of saying you can't actually make your $10,000 mortgage payment that you took out a month before you declared bankruptcy? How would it, under your understanding of how the statute works, how would a bankruptcy court disavow that?
Well, you'd have to turn to the initial provisions of 1325, which those are the requirements for confirmation. 1325, I think it's A3, is the plan has to be proposed in good faith. If the debtors, and you see this in the what we call Chapter 5 context of fraudulent conveyances, like if you are intentionally taking money and hiding it from your creditors, that's a fraudulent transfer. That's a fraudulent transaction. And so these indicias of bad faith, you've badges of fraud, things of that nature.
So the court wouldn't allow you, the way the court would do it is they wouldn't allow you to declare bankruptcy in those circumstances, or you couldn't confirm a plan.
It's not so much that. I guess you'd file, the procedural mechanics would be, file the case, there'd be the objection to confirmation, the judge would deny confirmation of that plan, and if the debtor can't come back with a confirmable plan, the case would be dismissed.
Okay.
And so it's not as though, I mean, hypothetically, the case could be converted to a Chapter 7 if that was in the best interest of creditors, to where if there was substantial equity, the house could be liquidated. But that's not a means test issue, that's more of a good faith issue. And I mean, this is a scenario where, the particular county where my clients live is the second largest geographically in North Carolina. Like, they happen to live close to the beach. So are they punished for that? So, because let's get into, if we go down this rabbit hole of reasonableness is now grafted onto the statute even when it's not there. So how do we approach this? So what, is this court then going to craft the reasonableness standard that we have to follow in these types of cases? Because that's going to split with both the Sixth and the Ninth Circuit. So we're going to create a circuit split right there in and of itself. What do we do? What do we look at? Like the interest rate? Like maybe your payment is too high and unreasonable because you had a bad interest rate. Well, maybe you had a bad interest rate because you defaulted on your credit cards and you couldn't refinance your mortgage. Like, how do we do this? Like, how does a debtor present this information to the court? And at what cost? Is there going to have to be a separate brief filed at confirmation showing the reasonableness why I get to stay in my house? If you're current with your mortgage payments and there's no equity above exemption, you keep your house in bankruptcy. And so, especially in a Chapter 13, the debtor always stays in possession and control of their property. So you're having to justify staying in your own home. I don't understand that. So what if it's a debtor who wanted to live in the best school district in the county, but that requires living in a more expensive house? They did that as an alternative to sending their kids to private school and maybe more. Where do we draw these lines? What does that look like? And again, if we start finding that your payment's not reasonable, do you have to leave the house? Where else are you going to go? Do I then also have to show you what the rental market looks like for when I have to let my house go? Do I have to show you what else is on the market that I could be buying? The affordability with interest rates? Are we really going to micromanage people's lives to that extent to determine where you get to live? Like, not only are you filing bankruptcy because you can't afford your debts, but you're filing a bankruptcy to have a judge tell you where you get to sleep going forward. This is exactly what BAPSIPA didn't want. Like, we have to listen to Congress at some point when they said judicial discretion is being removed. Shall is being used all over these statutes because Congress has said if we put it in the code, you follow that, that makes it reasonable. We've called it reasonable. And again, we know the Supreme Court has said on many occasions, we want stability in the mortgage market. You're not going to have stability in the mortgage market if there's a question of when you file bankruptcy, even if you're current on your home, there's no equity above exemption, you still might have to give it up. That can't be what Congress intended. And so I additionally want to point out, if we go down this road of following the trustee here, are we going to mark up the official forms in just the Fourth Circuit? So we're going to say, well, in the Fourth Circuit, these forms need to go ahead and say, there's a possibility at confirmation you're going to have to justify the reasonableness of your mortgage expense. Because reasonable already appears in other places in the law. So are we going to change these official forms just for the states in the Fourth Circuit? How's that going to look? How does that work in practice? It's just going to create too much confusion. Bankruptcy Rule 1001 says we need to interpret these rules for the just, expedient, and cost-effective determination of cases. This is going to do the exact opposite. Confirmation hearings today in a Chapter 13 case take place in about 15 seconds. Judge reads out a list of cases. Are there any objections to confirmation? No. We confirm the cases. But what happens now is, if this is an arrow the trustee can have in his quiver of like, you got to show me that this mortgage payment's reasonable, we're going to be having half-hour, 2-hour confirmation hearings per case. So when you have a calendar with 15 cases, we're going to be here all day. We're going to be here until tomorrow. So what judicial resources are we going to waste on this reasonable determination when Congress has said we don't have to have this reasonableness determination? It has to mean something if in Clause 2, the word necessary appears 7 times. You see it 7 times, necessary. Or reasonable. The word reasonable appears 7 times in Clause 2. It doesn't appear once in Clause 3, and Clause 3 is what lets you deduct the mortgage payment. If you have the payment, you're good. And we know Hamilton versus Landy, you actually have to have the payment. If you surrender the property, you can't deduct the secured payment. But if you're keeping the property and you're going to keep making the payments, you get to deduct the whole payment on the means test. And so, in closing, the plain language of these statutes could not be more crystal clear. Shall means shall. It removes judicial discretion. Both the Sixth Circuit and the Ninth Circuit were correct on this issue. The Supreme Court in Ransom versus FIA Card Services in 2010 was also crystal clear. FAPSIPA has taken discretion away from bankruptcy judges in favor of a bright line test. Sometimes that bright line test may end up with some results we don't like. That's not our job to address the propriety of that. Public policy concerns are going to be addressed by Congress. Pelley's asked that the lower court, the bankruptcy court, be affirmed. I'm open to any other questions.
All right, no other questions, thank you, and we'll hear again from Mr. Bledsoe. Why don't you tell us why shall does not mean shall? Why doesn't it mean shall in Clause 3?
Well, I think it means, well, first of all, shall means shall, but what it doesn't say is that the debtor shall get a deduction for these amounts. What it says is that the amount of secured debts shall be calculated in this manner. Now, it's a perfectly, I think, reasonable interpretation to say, yeah, the debtor gets those, but at the same time, if you read the whole part of 707D, you read all the different clauses, they kind of latch on to each other. They overlap a little bit.
All right, thank you for your argument. We'll come down and greet counsel and then hear our last case. All right, our last case of the day is Cruz versus Garland. And Ms. Vera, I understand you'll be arguing and also introducing your co-counsel? All right, go ahead.
May it please the court, Paulina Vera, pro bono attorney with the GW Law Immigration Clinic on behalf of petitioner Mr. Cruz. I will be splitting my time today with GW Law student Cornelia Waugh. In this case of first impression before the Fourth Circuit, the issue at case here is whether a Virginia statute criminalizing...
As you get started, could you just explain for the court how you're going to split the issues so we don't step on your arguments?
Certainly, Your Honor. So I will be addressing two issues, the first of which is that de novo is the appropriate standard of review. Secondly, I will be addressing that intent to deceive alone does not categorically make a statute a crime involving moral turpitude, while Cornelia will be addressing the realistic probability test.
All right, go ahead.
So in this case of first impression before the Fourth Circuit, the issue is whether a Virginia statute criminalizing a 30-second mistake is categorically a crime involving moral turpitude.
Can I stop you right there? I don't understand how this is a statute criminalizing a mistake. I mean, I'll tell you what I think is the hardest problem in this case for me. Your client's description of what he did is inconsistent with the statute to which he pleaded guilty. Because if he made an innocent mistake because he misunderstood the officer, he is not guilty under this statute. And so I don't know what to do with the fact that his testimony is inconsistent with the requirements of the statute.
Well, Your Honor, Ms. Waugh will be addressing how we can bring in the facts of this case under the realistic probability test. I will be looking more at the elemental language, which I'm happy to address.
To which he pled guilty. That's the problem that I think Judge Heitens is raising. He pled guilty to intent to deceive.
Correct, Your Honor. And I am going to argue that intent to deceive alone actually does not rise to the level of a crime involving moral turpitude.
But it's not just intent to deceive alone, it's intent to deceive a law enforcement officer.
That's correct, Your Honor, and I will...
It's not intending to deceive an insurance agent, my friend, my neighbor. I have to intend to deceive a law enforcement officer.
That's correct, Your Honor, and I will address that right now. Yes, there is a specific intent to deceive a law enforcement officer as to a person's identity. And the government argues that this is what makes the Virginia statute inherently fraudulent. There is this idea that generally crimes involving intent to deceive are considered to involve moral turpitude, but note the qualifying language generally. I asked this panel to look at our sister circuits in the 7th, 8th, 9th,
Why don't we address our circuit? What would you do with our Ramirez case?
Yes, and actually the 7th, 8th, 9th, and 10th circuits were favorably cited by this court in the Nunez-Vasquez case.
Okay, but what about Ramirez?
Yes, Your Honor. And so Ramirez does differ from this case at hand because in that case, there was a result-oriented approach to the way that statute is written. So the reason that intent to deceive alone does not rise to a level of a crime involving moral turpitude is because, like other circuits have said, here a false statement can violate the statute even if it doesn't actually impede the investigation. So here the lawful intent detention has already taken place, and there's no requirement that the false ID led to any actual harm. We know that legislatures know how to write those harms in the statute. If you look at Nunez-Vasquez, that was a Virginia statute which specifically listed the results of to avoid summons, arrest, prosecution, or to impede a criminal investigation. This is similar to some of the other cases cited by both Cornelia and myself, as well as the government. And Jurado Delgado, the Pennsylvania statute there, specifically listed an intent to mislead in official functions. Here we simply have an intent to deceive as to one's identity, but it is not necessarily.
Well, but it's actually not just that. It's intent to deceive about my identity after being lawfully detained, right? I don't think we can split up this statute into intent to deceive or even intent to deceive a law enforcement officer. It is intent to deceive a law enforcement officer about who you are after you have been detained. Why doesn't that necessarily have at least predictable impact on impeding an official investigation? It strikes me the only reason you would mislead someone about your official identity after having been lawfully detained is because you are trying to, well, mislead the officer for some reason, presumably because you don't want them to figure out who you really are.
Yes, Your Honor, and that may be one result that does stem from this statute, but
I guess the analogy I'm drawing is to 18 U.S.C. 1001, which requires materiality, but materiality doesn't require that it actually affect the law enforcement investigation. It requires that it have a predictable or reasonable probability of impacting a law enforcement investigation. This seems like a really similar statute to me. Sure, could I imagine a situation? I mean, my chamber staff came up with an example about a person who looks just like Keanu Reeves saying, "I'm Keanu Reeves." And then the officer goes, "Really?" And you're like, "No, just kidding, haha." Fine, that person I theoretically might violate this statute, but it seems like the overwhelming likelihood of instances where you are attempting to mislead a law enforcement officer about your true identity after being detained will have at least a reasonable probability of affecting an official investigation.
And again, Your Honor, that may be the case, but again, we look at minimum conduct, right, that can be prosecuted. And so again, Ms. Wall will address the realistic probability test, and sort of similar to your hypothetical, right, there was an instance there where a person without status was nervous in the moment, gave a incomplete name, and then within 30 seconds corrected that mistake. So
What is the minimum conduct here that could be prosecuted that does not involve deceit?
So again, looking to even to our own case, which we're allowed to do under the realistic probability test, we have a case where the investigation actually was not impeded because within 30 seconds, our client gave not only his real name, but additional identifying information. That is his birthday, right? And there was no impeding of the investigation because the lawful detention was not impeded. He was ultimately charged, went to court. So none of those lawful processes.
But the statute itself requires with the intent to deceive the law enforcement officer. So what is the conduct that could be punished under this statute that doesn't require an intent to deceive?
Your Honor, I see that I have about 20 seconds left. May I?
Yeah.
Okay, and could I piggyback on that? It seems to me your better argument is not that there is an intent to deceive because he admitted intent to deceive, but that it isn't conduct that independently violates a moral norm. And I haven't heard you talk about that at all. Are you abandoning that as part of your argument or not?
Your Honor, and I think the Eighth Circuit case of Bobadilla is instructive in that because in looking at very similar conduct to our present case, the Eighth Circuit said, right, folks that get stopped in a traffic stop are maybe not acting their best self, right? They may be nervous in the moment, they may give misinformation, but that doesn't necessarily mean that that conduct is going to be morally turpitudinous, such that it is a categorical match to a crime involving moral turpitude. Thank you, Your Honor, and I will now turn it over to.
All right, thank you. And Ms. Wall, we'll hear from you.
Your Honors, my name is Cornelia Wall, student attorney with the GW Law Immigration Clinic. I would like to highlight that this case is about 30 seconds that now has a family wondering if a lifelong partner and a loving father will remain home with them. So today I will discuss the realistic probability test and conclude that no morally turpitudinous conduct was involved in Mr. Cruz's conviction. His conduct did not shock the public's conscience as being base, vile, or morally depraved. In this case, the BIA erred in a number of ways. First, the BIA, with no with no support from any authoritative case law, agreed with the IJ that since Mr. Cruz pled guilty to his conviction, he was restricted from pointing to his own case for the realistic probability test. The BIA also concluded that Mr. Cruz did not submit a plea colloquy or a court transcript and therefore could not prove that the statute was overbroad in its
So how is it that the realistic probability test undoes his guilty plea to intent to deceive?
Your Honor, so the realistic probability test doesn't undo his guilty plea, but what we're arguing here today is...
Undermine the fact that he pled guilty to intent to deceive.
Could you repeat your...
How does the realistic probability test undermine, undercut, discount the fact that he pled guilty to intent to deceive?
Well, Your Honor, based on case law, a guilty plea never precludes the court from looking at the realistic probability in terms of a non-citizen. And even in the case that we're arguing today, Your Honor...
What is your best case for realistic probability here?
Well, Your Honor, for realistic probability, we've cited to Silva Trevino, we've cited to Nunez Alvarez, and even cases where non-citizens have pled guilty, such as Mataro Ferreira, United States versus Johnson. And in these cases, Your Honor, defendants have pled guilty, and the court never used that against them to say that they are not eligible for the realistic probability test.
Oh, I don't think there's any question that your client is entitled to the realistic probability test. I guess I'll ask you the question I asked your colleague, which is, when I read the blue brief's description of what he did, that person is not guilty under this statute. And so I don't know how, but he pleaded guilty, but your client pleaded guilty. And so I certainly agree your client can take advantage of the realistic probability test. He can certainly point to other people's cases. He can even point to the facts of his cases, but whether it's preclusion, whether it's full faith and credit, I just don't understand how, as a way of showing that this statute applies in a particular situation, we can look at the fact of your client's case and his account of an action that, as described by him, does not violate the statute. He's not guilty. He should have pled not guilty, and he would have been acquitted. And so I don't see how we can consider that. And I guess when Judge Thacker says, what case says we can do that?
Well, Your Honor, there's no case law that says you can or can't do that. There are many situations where non-citizens have pled guilty to offenses, but I don't believe that in any way, Your Honor, bars him from showing that his conduct in this case doesn't rise to a level of moral turpitude.
Do you know if he was advised, did he have counsel in the underlying proceeding?
So later on, he did have a public defender in this case, Your Honor.
Do we know if he was advised of the immigration consequences of his guilty plea under Padilla versus Kentucky?
Your Honor, may I get back to that on rebuttal?
Absolutely, absolutely.
Okay, thank you.
It just strikes me, so Padilla is the case that the Supreme Court says non-citizens have a right to be advised of the immigration consequences of pleading guilty before they do so. And it strikes me here, I guess one question is, did his counsel tell him? And if his counsel didn't have him, he might have had an ineffective assistance of counsel claim.
Yes, Your Honor, I understand. So, Your Honor, I would like to move on to the fact that Mr. Cruz's testimony in this case was sufficient. He testified under oath before the immigration judge, and the government did not dispute the facts involved in this case. I would also like to add that general district courts in Virginia are courts not of record, so oftentimes judges are not required to even put plea bargains in writing, and they don't necessarily
Well,
have...
excuse me, counsel, have you been in a general district court in Virginia?
No, Your Honor.
Okay. There is no such thing as a written record, okay? There are no plea colloquies. I mean, it seems to me that in reading the briefs and listening to argument, there's a disassociation from reality going on here as to what occurs in a criminal court, in a general district court in Virginia, when there might be 200 or 300 people processed in 2 hours. And both sides are discussing a situation that is not reality. And that gives me a lot of concern. So perhaps you could take that into account.
Yes, Your Honor. Thank you. Thank you very much for that. To proceed, Your Honor, I would like to highlight Mr. Cruz's conduct the day of his arrest. The police officer approached Mr. Cruz and asked him for his name in incoherent Spanish. Mr. Cruz gave his correct first and last name, which is typically acceptable, and noticed that there was some confusion. Within 30 seconds, Your Honor, Mr. Cruz wrote down his correct first and last name and gave his date of birth. Your Honor, in this case, Mr. Cruz's conduct was not morally...
So are you saying he never gave a different name?
Yes, Your Honor, he gave an incorrect middle name, but what I'm arguing here today
He
is that...
left that part out.
I'm sorry, Your Honor.
That's
He
the key
gave-
part. That's the deceit.
Yes, Your Honor. So he gave his correct first and last name and an incorrect middle name. The police officer did ask him for his name again, this time in complete English, and this is when Mr. Cruz wrote down his name for him on a piece of paper and also gave his date of birth. Your Honors, I understand that Mr. Cruz's guilty plea is of some contention, but I do want to point out that we're looking at the minimum conduct that was prosecuted. And Mr. Cruz was arrested and convicted and charged for the Virginia Statute 19.2-82.1. Regardless of whether he pled guilty, Your Honor, the conduct on the day he was arrested falls outside the scope of what is typically considered to be a crime involving moral turpitude. I thank you, Your Honors.
All right, thank you. You have time in rebuttal, and we'll hear from Mr. Minnick now.
Good morning. May it please the court, William Minnick, representing the respondent. The offense in this case is a crime involving moral turpitude because it expressly requires an intent to impair a government function by deceit. And so the board's decisions in matter of Florida...
Well, it doesn't require an intent to impair a government function. According to the wording in the statute, it's an intent to deceive the law enforcement officer as to his real identity.
That's right. Correct, Your Honor. So the statute does involve specific intent to deceive, and it bears on a government function. So the board's decisions in Flores and Jurado are controlling.
So you're saying that it necessarily requires a violation of an independent moral norm, which is what we say is generally required for a crime involving moral turpitude. There has to be an independent norm, moral norm that's being violated, something intrinsically offensive morally about this conduct. Isn't that correct?
That is correct, Your Honor. And
Okay, so then if I come into court and I'm charged with no operator's license, not driving without a valid operator's license, which happens every day in Virginia, okay? And I have, at the scene of being detained lawfully by the police, I tell the police officer that I'm my sister, okay? I intend to deceive the police officer because I'm underage, or because I already have a speeding ticket, and when the officer runs the record check, he's going to find that I have a speeding ticket. And what independent moral norm is violated because I've been driving a car 6 months short of my 18th birthday, and I don't want the police to know about it? Where's the independent norm being violated there?
it's the intent to deceive, Your Honor. In Nunez, this court...
So you're saying per se, it's intent to deceive. That's all that's required.
It's not
So if I lie to an officer about my age, okay, let's just say that I lie to an officer about my age per se. You're saying that's a crime involving moral turpitude.
This court has said in Ramirez that
No, but I'm asking you about the independent moral norm.
deception. This court says fraud, deception, these are aggravating factors that make violation of a mere statute. They elevate it to violating a moral norm. This court said...
So if I drive without a valid operator's license in Virginia because I am 6 months short of my birthday, I have violated an independent moral norm when I tell the officer that I'm my sister, who is old enough to drive and has a license?
If the statute requires an intent to deceive and you make a false statement to the police officer, yes, that's a crime involving moral turpitude. In Ramirez, this court gave examples of aggravating factors that elevate mere violation of a law to a violation of a moral norm. And it said, we hold that obstruction of justice in that case is not a CIMT because it may be committed without fraud, comma, deception, comma, or any other aggravating element that shocks the public.
Right, but in Ramirez, it also says that it's a CIMT if the intended obstruction is an immoral act or result. So what is immoral about driving without a license and telling the police officer that I'm my sister? What's intrinsically more immoral about that? You're saying just because I lied. Anytime I lie about my age, about anything, and I'm driving without a license, I've violated an independent moral norm of society.
The statute requires an intent to deceive, yes. If you intend to deceive the officer and make a false statement to the police officer, that's an obstruction type crime with an aggravating element, deception.
Okay, can somebody intend to deceive then by initially giving an incorrect name and then correcting it? I mean, is an independent norm violated if I give the wrong name, intending to deceive, but then I correct it a few minutes later? Have I then committed an intrinsically immoral act by initially giving a false name even though I corrected it?
Yes, Your Honor, because the moral turpitude derives from your initial response to the police, your intent to deceive them and give them a false name. The fact that it's subsequently corrected does not go back and erase the moral turpitude.
Well, in moral turpitude, in Ramirez, we noted that the BIA defines moral turpitude as behavior that, quote, shocks the public conscience as being inherently base, vile, or depraved. How does what Judge Keenan is describing, or the facts of this case, how is that moral turpitude as the BIA has defined it? Inherently base, vile, or depraved?
They defined obstructing, in Flores, they set out their definition that inherently base, vile, or depraved includes obstructing an important government function through deceit. And then they built on that in matter of Jurado, in which they said deceit, the deceit is critical. And then in Ramirez, this court, in discussing Jurado, said in Jurado, deceit was the critical aggravator that rendered an obstruction offense a CIMT. And of course, in Ramirez, it went on to point out that the statute in that case did not involve an intent to deceit. So that offense was not a CIMT. But the aggravating factor that elevates an obstruction type offense above a mere violation of a law is intent to deceive. That's what the board said in Flores and Jurado.
Okay, so if my driver's license says that I require corrective lenses, okay, and I tell my updated driver's license, and I give the police officer my old one that doesn't show corrective lenses back when my vision was good, am I then committing a crime involving moral turpitude because I'm saying, or we can even go back to my sister. Go back to my sister has better vision than I do, so I'm giving her her license. That is immoral and depraved.
Well, I mean, that wouldn't be a violation of the statute.
Why wouldn't it? I'm saying that I'm my sister.
Oh, okay.
And I apologize. I think I confused the hypothetical as I launched. But it seems to me that you're just saying ipso facto, if you intend to deceive, doesn't matter about how minor it is. If you say something that's not true with the intent to deceive, case over. Done. Sealed, signed, sealed, and delivered.
Well, I mean, under the statute at issue here, yes, if you give a false name to a police officer after you've been detained, after the officer asks you for your name, with the intent to deceive the officer as to your identity, then yes, I mean, that's a serious crime. It's an important government function. I mean, once officers detain someone, it's important in real time that they ascertain who they're dealing with to see if the person owns the vehicle and is licensed to operate the vehicle and has outstanding warrants. So yes, in terms of this statute, once you intend to deceive and give a false name after you've been detained with the intent to deceive the police officer, that's morally turpitudinous. It's the intent to deceive under matter of Flores and matter of Gerardo.
So it doesn't matter how little the intent is. You're saying if you have a scintilla of intent to deceive, that's...
I guess what I'm saying is it's not the underlying crime. Like it's not, it doesn't encompass the reason you were pulled over by the police in the first place if you were driving on a suspended license or underage. Like that, the moral turpitude doesn't derive from that. It derives from after you've been detained, lying to the police with the intent to deceive them.
So lying to the police is inherently base, vile, or depraved, no matter what you're lying about. That's your case, isn't it? With the intent to deceive. In other words, if you
After
lie...
having been lawfully detained.
And about your identity. It's not.
Right.
It's not an actual lie.
So if you lie to the police about your identity with the intent to deceive them, I'm telling you I'm my sister, she's old enough to drive, that is automatically base and deprived and immoral.
Because it's done with an intent to deceive, yes, under the board's decisions, which are controlling here, Flores and Gerardo, obstructing the government with an intent to deceive is, under the board's definition, inherently base, vile, and depraved.
What about the Keanu Reeves hypothetical I asked the other side? So I'm someone who looks improbably like Keanu Reeves, and I get a lot of joy out of tricking people. And so I get pulled over, and they say, "What's your name?" And I say Keanu Reeves. And I do, in a moment, hope that you believe me when I say that. And I hope for that reaction, the one you're going to laugh at. I don't actually, I'm going to own up to it, because eventually I'm going to give you my driver's license, and eventually you're going to see I'm not, in fact, Keanu Reeves. I actually think that person might violate the literal language of this statute, right? My goal is in the moment for the law enforcement officer to believe me when I say I'm Keanu Reeves.
I guess my reaction to that is, I mean,
There's probably not a realistic probability of being prosecuted, fair enough, but.
that's true, Your Honor, and I agree with that. I guess that I should have led with that. And secondly, I'm not sure the facts of that case. I know you said in the moment you wanted the officer to believe that, but
Yeah, in the moment, I want him to believe it.
I don't know if there's an intent to deceive in that scenario where you're joking and you come up with, you look like Keanu Reeves and you come up with that. You're joking, you're going to correct yourself. I mean, I guess in your hypothetical, what if the officer really...
Maybe he'll let me go. Maybe he'll buy it and just let me go. Because he doesn't want to give a ticket to a celebrity.
You said, you responded and said, you're going to correct yourself. What about the fact that petitioner here corrected himself within 30 seconds?
Well, I think that's just not relevant to the CIMT analysis. That's the type of argument that should
But
be
it
made.
sounded like it was relevant to the analysis when you were responding to Judge Hyten's Keanu Reeves hypothetical.
Well, maybe I misspoke and got caught up in the hypothetical, but the correction's not relevant to the CIMT analysis because the moral turpitude attaches when you give the false name to police with the intent to deceive them. And what happens after that? The correction doesn't erase the moral turpitude.
Because that's the aggravating factor under the case law, correct?
That's correct,
The
Your Honor.
intent to deceive.
And even here, I mean, he did correct it quickly, but it was only after having been asked a second time by the police what his name was. So it seems like at that point, they had run his brother's name and it didn't check out, and he knew he was caught in the lie. So probably, it seems based on the record that there was no point in continuing, and he had been arrested before, so he knew he'd be identified from his fingerprints eventually. I mean, the fact that he gave up on trying to deceive the police doesn't erase the moral turpitude of having done it in the first place. And he did have a reason to give a false name. The objective evidence in the record indicates that he knew he had failed to appear in his 2011 criminal case. That's Joint Appendix at 377, 383, 265, and 381. And he had a second reason to give a false name to police in this case, because when in addition to having failed to appear, and the record indicates that a bench warrant had been issued against him, that's appendix at 383. In addition to that, he was also then in 2013 driving on a suspended license.
So perhaps the distinction between Judge Hyten's hypothetical in this case is bad faith, his Judge Hyten's hypothetical good faith when the deceit occurred.
Well, I mean, to go back to the Keanu Reeves hypothetical, I mean, I think if there really were an intent to deceive, thinking the officer would, you
might let me go.
You would avoid the ticket if you could really convince the officer that you were Keanu Reeves. In that case, I think it could be prosecuted under the Virginia statute.
Versus if my intent in the moment was, if the officer bought it, to say, haha, just kidding.
Yeah, I mean, I think when you posed the hypothetical to them, you said, I was just joking.
Then I'm just going to laugh. They'll say, really? They'll look confused, and then I'll say, no, man, I'm just kidding with you. Here's my driver's license.
I don't think there's a real intent to deceive. It would support a guilty plea on those facts. But the other hypothetical where he's really trying to convince the officer that he's actually Keanu Reeves because he thinks he might avoid getting a ticket, I think that would be prosecuted under the statute because it's an intent to deceive, and he's given the officer a false name after being detained. And I'd also like to say that, I mean, there's no meritorious reason to give an officer a false name after having been detained. It's to avoid scrutiny or avoid arrest or deflect an investigation or pass the blame onto someone else by framing them. There's no meritorious reason for doing it.
And you're saying it absolutely doesn't matter why you're doing it. It's simply the act of deception. Is that correct?
Yes, that's correct under the board's definitions in Flores and Gerardo. That is correct, Your Honor.
And so it doesn't matter if your conduct is independently violating a moral norm. You've intended to deceive.
No, what I'm saying is the intent to deceive
Is baked in. You're saying it's baked in irrespective of how trivial your reason is for doing it.
Yes, Your Honor. I'd like to address one thing. Your Honor asked about whether his criminal case has been vacated, and that is addressed on page 26 of.
Oh, I didn't ask whether it had been vacated. I asked whether he'd have a plausible basis to vacate it on the grounds of ineffective assistance of counsel.
He did make that argument, and it was denied in 2016. That's the footnote in his appeal brief to the board. It's page 26.
So he made it in the Virginia state courts, you said he made it. He made basically a post-conviction motion to vacate in the Virginia state courts?
It's just, and this is what they wrote in the appeal brief, it's just he attempted to vacate his plea, but was denied by the Virginia court. And I'd also like to point out, to the extent that the facts that he related to the immigration judge are inconsistent with his guilty plea to this offense, I'd like to invite the court's attention to Rodriguez. That's a Second Circuit case I cited in my brief. That's the case that, a published case that deferred to Flores. And Rodriguez has raised the argument that it was a false statement in a passport case, and he raised the argument that he honestly believed the statement wasn't false. The Second Circuit just rejected that on the basis that it was inconsistent with his guilty plea. It said, having pled guilty to the offense, he has admitted all of the elements necessary for a conviction, including knowingly submitted false information to obtain a passport. And this court should do the same. It should reject his version of events as related to the immigration judge as simply inconsistent with his guilty plea. That's what the Second Circuit did in Rodriguez.
All right. Do y'all have any other questions? Thank you.
Court to deny the petition.
All right, thank you. We'll hear again from Ms. Vera.
Thank you, Your Honor. I will address two issues on rebuttal. First is the Rodriguez case that my friend here cites to, and second is the Ramirez Sessions case of this Fourth Circuit. So regarding the Rodriguez case, I will note that that case, that statute is different from the statute that we have here at issue because the language of that statute says to knowingly make any false statement with an intent to induce or secure the issuance, again, which necessarily involves fraud, a way that we don't have here. And so I would ask this court not to conflate these concepts of deceit and fraud because as the 7th and 8th Circuit, or sorry, excuse me, the 7th and 10th Circuit have pointed out in doing an analysis of deception-based CIMTs, they said that usually those types of statutes involve some sort of actual or intended harm, again, in a way that we do not have at this present statute. Regarding the second issue of Ramirez, yes, in the Fourth Circuit in Ramirez did say that deception, right, could be an aggravating factor such that it would make a statute rise to the level of a crime involving moral turpitude. And I would note that if intent to deceive hadn't been in that particular statute, then perhaps, yes, there would have been a finding there that that was a crime involving moral turpitude. Because again,
But that's the point. It is in this statute. It is in the statute we're dealing with.
But Ramirez had something plus that we don't have in this statute. So the language of that is knowingly obstructs a judge in the performance of his duties. So again, the legislatures know how to write this sort of result harm in the statutes in a way that they did not in this Virginia statute. For those reasons, Your Honors, I would ask that you please remand to the Board of Immigration Appeals with instructions to remand to the immigration judge for further fact-finding consistent with the holding that this Virginia statute is not categorically a crime involving moral turpitude. Thank you.
All right, thank you. Ms. Wah?
Judge Heighton, I would like to address the matter you asked me about the public defender in Padilla. Sure. So the public defender, we did try to get the relief in district court, but the public defender had made a one-line note that he advised of immigration consequences, but he did not state what type of advice was given or what the advice exactly was, and the judge held that that was enough and denied or appealing that case. I would also like to address the matter of intent to deceive in regards to the realistic probability test and Mr. Cruz. Even if Mr. Cruz did, in fact, have an intent to deceive when the police officer approached him, within a matter of 30 seconds, Mr. Cruz amended his mistake. I'm afraid that if we find, Your Honor, that his conduct does rise to the level of a CIMT, it would discourage other individuals from honestly communicating with police officers after making a mistake within a few seconds. I would also like to address the government's position of the hypotheticals they made up in regards to deceiving the police officer, that Mr. Cruz might have known that his name would pop up or the officer would find out who he was. There is credible testimony given by Mr. Cruz in this case. He testified under oath, and opposing counsel never at any point disputed the facts in this case. Mr. Cruz stated that within 30 seconds, he corrected himself after the police officer asked him for his name in incoherent Spanish. He told the officer, "You do not understand," and actually took a paper, wrote his name, and additionally gave his date of birth. Your Honors, this conduct is not morally turpitudinous. It's not depraved, it's not vile. It was just a mistake that Mr. Cruz corrected in the moment. Thank you, Your Honors. I ask that you remand the case to the BIA. Thank you.
All right, thank you very much. And on behalf of the court, we particularly want to thank Ms. Vera and Ms. Wah and the entire GW Law Immigration Clinic for your work on behalf of your client. And we also appreciate the able representation of Mr. Minnick on behalf of the United States. We'll come down and greet counsel and ask the court to adjourn court. Sine die.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.